Okay, hello everyone. Good day to you all. Welcome to our webinar today entitled What to Know When Your Medicare Set-Aside Totals Zero. My name is Heather Sanderson. I'm the founder and CEO of Sanderson Firm. I have been in the Medicare Secondary Payer industry for nearly 20 years and dedicated my entire legal career to Medicare Secondary Payer. Deeply passionate about this topic. Tell you about Sanderson Firm in a moment. But in the meantime, I would like to have our great panelists, Annie Davidson and Brendon De Souza, introduce themselves and tell them about themselves. Annie, can you please give an intro?
Yes, absolutely. Thanks, Heather. Hi, everyone. Annie Davidson here. I am an attorney by trade, licensed to practice in Minnesota state and federal courts. I've been over with Sanderson Firm for a few months now. Prior to that, I also have worked extensively in the industry on the vendor side. And then prior to that, I was in private practice handling work comp and liability and no-fault insurance defense cases at a mid-sized firm in Minnesota, which is where I hail from. Brendon, turn it over to you.
Hello, everyone. My name is Brendon De Souza. I'm the Chief Legal Officer here at Sanderson Firm. I've been in the industry since 2017. So I started at a large national provider of Medicare Secondary Payer services and sort of learned everything, all things MSP compliance from the ground up. But I am excited to be here today. 2025 is obviously has a lot of changes, both with reporting and with MSA. So I think everyone will walk away with some very useful information after today's presentation.
Agreed. It's a very timely topic. There's a lot of commotion around MSP and certainly around zero MSAs, and we'll tell you all about that. Okay, let's go ahead and get started. Okay, so our agenda for today, we're going to provide the CMS update regarding everybody's been asking what's going on with all the federal layoffs and this new DOGE agency and what impact is that having upon MSP and outside of actually what's going on with a certain with the Trump administration. Actually, there were already some movement within the Centers for Medicare and Medicaid Services, which we'll share with you all, and how that will impact day-to-day in MSP. We're going to do a level set just on MSAs and zero MSAs, just to make sure everyone's on the same page before we dive into talking about the relevant updates coming about with zero allocations. We're going to obviously point in on the very exciting update that as of July 17th, 2025, CMS will no longer review and approve zero allocations. I think I have no qualms about being honest that very much applaud this move by CMS. We'll talk about that later, why we think this was a great move for CMS to stop approving zeros. There were a lot of problems in the past with getting those approved, and especially in situations where the zero was warranted. So we'll talk through that and how you can handle and still settle out cases with a zero allocation, even despite the fact that you cannot obtain CMS review of a zero going forward. We're going to talk about the interplay with Section 111 reporting, as well as conditional payment resolution. We're going to also discuss settlement considerations and wrap up. Just a little bit about Sanderson Firm. So we are a law firm specializing in all things Medicare Secondary Payer. We provide all different types of Medicare set-aside allocations. We also do conditional payment resolution and disputes and Section 111 reporting and audits. And I'll provide a list of services at the end of the presentation. We pride ourselves on our innovative approach to MSP, right? We are thinking outside of the box. We're nimble and we are adaptive to the currently ever-evolving CMS landscape, right? We are a fully woman-owned business. We do have our woman-owned certification. Our footprint is nationwide. So I sit in Bradenton, Florida. Brendon's also in Florida, as Annie mentioned. She's in Minnesota. We have employees across the country, and we also have clients all across the country. We have done MSAs and MSP work in pretty much every state in the country. We service third-party administrators, self-insured employers, insurance carriers, as well as governmental entities. And we've grown tremendously year over year. We're just in year 5 of business and tremendous growth across the team. We have great legal, clinical, and claims professionals that we employ. We have been very fortunate to pick up some really, really great talent that has great deal of experience in the industry. Annie's a most recent example of that. Really just hiring some really great people to make sure that we're providing the best in class expertise and service to our clients. And I'm really proud of what we're building here at Sanderson Firm. We're now about 45 employees and growing. We've been doing a bit of hiring lately, and it's very exciting times for us. Certainly, I know that MSP is top of mind for all of you, and that's why you're here today, to get some relevant updates, and we're excited to provide those. So let's go ahead and get started.
Perfect. Thanks, Heather. So we'll kind of run through these updates that Heather alluded to. And I know if you joined us last month, we talked about these as well, but for some folks, right, they're just coming up to speed. And Congress, the federal government is kind of in chaos. So it's a fair question. It's a question, like Heather said, we get all day, every day. What's going on with CMS and what's the impact of what's happening in Washington? So the updates that we knew were happening are on the slide in front of you. So Steve Forey, who long ran the Medicare Secondary Payer area of CMS, which is housed within Health and Human Services, Steve Forey retired in January 10th was his last day. And then Jackie Sippa, his deputy, was promoted into the acting director of the MSP community. So she is in that role. And she is working in all of the ways that we saw Steve working before, and she's largely thought to be a continuation of Steve, right? Very level-headed, game to, collaborate in conversation with the community as much as she can, et cetera. Another change that was announced is that John Jenkins, who was overseeing the WCRC contract, the Workers' Compensation Review contract, he switched out of CMS, or at least the MSP division in CMS, and has moved elsewhere within the federal government. So Cynthia Gross, she has been put back into that role in the oversight program of MSA. She was in that role before John started, so some people think this is a welcome change. It will kind of go back to the way it was before. John Jenkins was a bit of a personality. If you had any interactions with him, you would know that. He had some strong opinions and preferences about things, and it really did impact. And it, in fact, impacted zeros a lot, I think. And Brendon will talk more about that later. But certainly, John's stamp on things was felt. So he's no longer in that division. Last month, I shared that there was a temporary pause of HHS communications. That remains in place for the CMS MSP division. They are still on a temporary pause in all communications. They can continue to talk to you about cases that they're actually working on, but they're kind of still working through what they can and cannot present and how they can meet with the industry. So you probably saw there is going to be a webinar coming up later this month by CMS. They're going to be talking mostly to beneficiaries and their representatives, kind of 101. They're able to do reminder trainings, informational trainings, things like that, and they're able to engage hopefully in listening sessions. So there is a listening session with the MARC Coalition on the 19th of this month and the 20th of this month, MSPN. I'm currently serving as the president of the National MSP Network this year. So MSPN's executive committee will meet with them on the 20th. So if you have questions, concerns, things like that you want us to raise in a listening session, please, contact any one of us and we'll pass that along and see if we can kind of get them out of the pause and out of listening sessions and being able to talk with us again. So that's kind of where we're at. In terms of kind of the Trump administration and where they're at, they did get RFK Jr. Approved. He was confirmed. So he is the head of Health and Human Services. Last we had heard they were looking at nominating Dr. Mehmet Oz to be the head of CMS. That has not happened yet, so more to come. Heather, Brendon, anything that I missed or any other updates you want to pass along?
I think you covered it.
Okay. Awesome. Well, then we'll move into a quick level set. As Heather went over the agenda, we just want to kind of get everyone oriented to what we're talking about today. And I can already see in the chat, some folks are super excited about this topic, and we will definitely get into what our zero iMSA product looks like, because that is what we're here talking about. We did tease that product last month. So you will hear more about that later on. But in terms of a level set, we are going to really be focused on Medicare set-aside today. Of course, we know that we all face 3 different threats in the Medicare secondary payer world. We face that of Section 111, mandatory insurer reporting. There are civil money penalties that you could get hit with there if you don't follow the statute and the regs. The goal there is coordination of benefits and feeding that information over to recovery. We're not going to spend a whole lot of time about that today. We'll talk a little bit about the interplay. That comes later, and Brendon will certainly cover for you everything you need to know before April 4th, when you have to be reporting information about your Medicare set-asides when you settle with a Benny. So we'll talk about that a little bit later. There's some interplay, but that's not our main focus today. Our main focus is not going to be conditional payments. We'll talk about that interplay a little bit later. But of course, that is one of the threats. So we have it up here on the slide. You want to follow the statute and regs around that to avoid double damages, lawsuits, offsets by Treasury. But our main focus today is all in Medicare set-aside world. And the key thing to think about when we are kind of dealing with this threat and moving through it is that this is not in the statute. This is barely mentioned in the regs. The regs, arguably, it's mentioned maybe in CFR 41146. But really, we're looking at sub-regulatory guidance. We have the WCMSA reference guide. That is agency guidance. The agency came up with that. They don't have any directive from Congress to have, come up with a scheme that's about enforcing, these MSAs. They've always been voluntary. The goal here is coordination of benefits. Post-settlement, how do we show that the parties aren't cost shifting onto the taxpayers? Or if you're going to be using a zero MSA, why that's appropriate. So we will be talking about that. And the ultimate risk that you face here is Medicare threatened to really not recognize the underlying settlement. Maybe they stop paying for care related to the person's injury and force them to use their settlement dollars. That's the threat we're looking at here, and that's what we're trying to mitigate. So that's it for the level set. I'm going to turn it over to Brendon to talk about MSAs, and then to start in on that zero.
Perfect. Okay, so obviously the topic of today is Medicare set-asides, and specifically $0 Medicare set-asides. But let's level set quickly here for those who are maybe newer to the industry or still learning just what is a Medicare set-aside. So a Medicare set-aside is a settlement tool, and it allows the parties to typically a workers' compensation settlement to set aside a certain portion of the individual's settlement funds for that person to use for their future claim-related Medicare-covered medical expenses. So to use an example, since examples add color and are helpful, let's say you have someone who works at a computer store, and a customer comes in and they say, hey, I want this keyboard that's on shelf number 9, right? And this employee is doing their job. They retrieve a ladder, and on the 9th rung of the ladder, they slip or they fall, and they fall on their arm. And let's say that's a significant arm injury, right? So you have someone who was injured during the course and scope of their employment. Let's say this individual was a Medicare beneficiary, and let's say this person proceeds with this compensable workers' compensation claim. What a Medicare set-aside would look like for that person could be, an arm surgery, physical therapy visits for the arm treatment, medications, maybe an X-ray, to just determine the level of fracture that occurred, right? So all these things, and a Medicare set-aside estimates specifically what treatment should be needed and the cost of those individual treatments multiplied out over the course of that individual's total life expectancy. So Medicare set-aside for that person could say, out of this $20,000 settlement, $10,000 is being set aside to pay for this person's claim-related arm injury post-settlement. Because the last thing Medicare wants is for beneficiaries or reasonable expectation claimants to receive lump sum settlements and not use any of those funds for their actual medical treatment. So the goal of a Medicare set-aside is to estimate as accurately as possible, right? Because it's not an exact science. The total cost that will be incurred for all medical expenses otherwise reimbursable by Medicare, and to set aside sufficient funds to cover those costs. So moving into the next slide, we see that there are different categories of zero, and the topic of today is specifically zero MSAs. So a zero MSA is, as the name implies, where nothing is being set aside for future medical care. And there's really two categories of this. So category number one is called a medical zero. This is a zero allocation type where you have the injured individual's treating physician, treating physician confirm in writing that this individual does not need any future claim-related Medicare covered medical care. Whether that's because the individual fully healed or maybe they were just never really injured in the first place. You have the doctor saying, hey, look, based on my medical expertise, this person doesn't need any medical care. And so because of that, the Medicare set-aside amount would be zero. Another example of a Medicare zero is a court order. So you could have a court order issued by a commission, a board, just a judge, issued after a hearing on the merits, confirming that no future medical care is appropriate. And so the key wording here is issued after a hearing on the merits. So typically the judge, the court, the commission, the board will hear evidence or testimony from a medical professional. So you may have a medical professional who evaluates the individual or that individual's underlying medical records. And that medical expert can reach the conclusion that, hey, this person doesn't need any medical care at all. And so a court would give credence to that or take that under consideration and say, issue a binding court order and say, yes, this is correct. The employer carrier is not responsible for future medical care at all. So those are two examples of medical zeros, which from just the inception of the Medicare set-aside program have been pretty consistent with CMS approving $0 MSAs that are submitted to CMS for review on that basis. But we also have a separate category called legal zeros, which is CMS has been extremely has been inconsistent recently on these. So legal zeros occur when the workers' compensation insurer or the self-insured employer denies responsibility for the claim under state workers' compensation law. No payments have been made for medical treatment or indemnity except for investigational purposes as permitted under state law. And we're going to talk about this specifically in a later slide. No benefits are actively being paid, and the settlement does not allocate amounts for specific past or future medical services. So you can think of these as your sort of, run-of-the-mill standard, just denied claim. So you have a workers' compensation claim, it's denied. Nothing has been paid under the claim. No medicals, no indemnity, nothing. And which is interesting that CMS has historically approved these, but what you'll see is CMS, up until at least recently, never actually acknowledged legal zeros in writing. But we'll kind of cover the history of this in the slides to come.
Okay. So let's talk about the history here. The old language that was in the reference guide regarding zero MSAs. So as CMS reiterates, submitting an MSA to CMS is never required. Always must protect Medicare's interests, but basically CMS set forth a three-prong approach where an MSA would not be necessary, meaning that the MSA should be zero. If this three-prong approach can be met, basically the facts of the case demonstrate that the injured individual is only being compensated for past medical expenses. There's no evidence that the individual is attempting to maximize the other aspects of the settlement regarding lost wages and disability portions of the settlement to Medicare's detriment. And the individual's treating physicians conclude in writing that to a reasonable degree of medical certainty, the individual will no longer require any Medicare covered treatments related to the work comp injury. But very interesting. So I just want to go back and talk about, the inception of the MSA program when the Patel memo was released in July of 2001, which was the first memorandum that Medicare ever released regarding MSAs, introducing the concept of MSAs and the CMS review process. Within that actual memo, Medicare talked about a distinction between commutation and compromise. Now, they don't really use this wording anymore, but what was interesting in that memo is they're basically saying a commutation is a settlement where a lump sum is being provided to a Medicare beneficiary to close out their claim, including their future medical component. And it's a compensable claim. That would be a computation in which an MSA should be included. Then they also talked about compromise cases. This is basically denied situations, a situation where basically a injury or a part of the injury is being denied by the work comp carrier. And so Medicare does not say that an MSA is necessary in those compromise situations within their actual memo. So I think from the beginning, and Annie or Brendon, let me know if you disagree with me. I think conceptually, when Medicare introduced the MSA program, they really only intended to review commutation cases, meaning cases which involve future medical in which the employer carrier has accepted that claim and accepted compensability for that. Would you agree?
I would agree, Heather. But I also think it, when we talk about this even now, the folks who, Mr. Patel, who wrote the memo, the folks at CMS, they're not necessarily lawyers who came from this industry in this area. They're not necessarily claims handlers or adjusters who work in workers' compensation. And so I do think there wasn't a lot of foresight into kind of the actual practice and what we face. And I think this sort of foreshadows some of, Brendon, what you'll probably talk about later, because I'm with you, Heather. But then I think later you end up with some folks at CMS interpreting settlements super broadly and arguing they don't care about compromise, and maybe defining it differently than we do in the practice. So maybe that's too much foreshadowing, Brendon, but maybe you want to comment a little bit here too.
Yeah, I agree. Especially in recent months, it's been apparent that CMS, as you said, Annie, never really fully either considered the language or was almost seemed like they were not necessarily making things up as they go, but sort of changing things ad hoc without what seemed like a bunch of the appropriate amount of consideration. So yeah, we'll talk about that later. CMS never quite had their foothold on when they would consistently approve at least legal zeros. That was never a really settled issue.
Yeah, a great points, Annie and Brendon. And the other thing I think what shows what you were saying, Annie, as far as CMS being out of touch with the real, practice of work comp claims and how they actually go. Well, number one, the third prong that we talk about here on the screen about obtaining a treating physician's statement to say that they're never going to need any future treatment. We know how hard that is to get, right? We've had some success. We reach out at Sanderson Firm on behalf of a lot of our clients and make it really easy for the treating physician to check a box that, the person will no longer require future care. But I think that standard was unreasonable and always has been unreasonable. And then I think the other unreasonable part is what you were talking about earlier, Brendon, which is obtaining an evidentiary court order, speaking to either the compensability of the claim or the fact that the claim meets the state law standards, right? An evidentiary court order in work comp practice is not a standard thing, right? Nobody wants to walk that very long path and go down that process. That's very expensive and tedious and not very commonplace at all in workers' compensation claims. So I think CMS has been out of touch with reality. Maybe they wanted to make it difficult intentionally so as to not approve a zero, but I think that both of those standards were certainly out of touch with the way work comp claims operate.
So, okay, so continuing on just the history of zero MSA. So by and large, right, so we have the Workers' Compensation Medicare Set-Aside Reference Guide, which outlines specific criteria where CMS would, approve MSAs in general, including zero MSAs. But CMS, well, at least the WCRC, the Workers' Compensation Review Contractor, this is the contractor that's tasked with reviewing Medicare set-asides that are submitted to it for review and approval. There's a period of time in 2016 where the WCRC kind of went rogue and decided to change procedure on when they would or would not approve a $0 MSA that was submitted to them for approval. And for the short period of time, essentially, the WCRC would not approve a $0 MSA submission unless either A, the submitting parties had a court order confirming that no medical treatment was necessary or a $0 MSA was appropriate, or B, the parties submitted treatment records demonstrating that no future medical care would be required. So what we saw here during this time was an obvious shrinking of the zero MSA review program. So you'll notice these two bases are medical zeros. So the legal zero category was just completely slashed. So you could have a fully denied work comp claim, never make indemnity payments, never make medical payments, and it could be absolutely legitimate, but the WCRC during this time would just simply require the employer or the insurance carrier to fund something for future medicals, which was obviously a drastic departure from CMS's prior, and the WCRC's prior handling of $0 MSA submission. So that happened, and then CMS very quickly backpedaled and issued a statement on this, which I'll let Heather go ahead, and I think Heather's going to go ahead and cover that statement.
Yeah, I remember the day that this happened and we were like, whoa, what just happened here? I mean, not enough notice was given to the industry. It was very disruptive. There was a lot of concern and angst amongst clients. So Medicare then says they've received inquiries regarding those changes, and they realized that they messed up because they implemented these changes without prior notification. So they went backwards. They backpedaled and went back to their old ways of reviewing zero MSAs. What else would you say about that, Annie? I know that you've been heavily involved with MSPN, that group for a long time that really talks to CMS a lot. Were you involved back then? And did you have any direct communications from CMS as to why they released this and then backpedaled?
Yeah, so I think this harkens back to, query whether this has to do with personalities. Like Cynthia Gross was not in charge at this time. And if you think about the timing, John Jenkins was probably pretty new. CMS has said that they don't see a lot of value in reviewing and approving zeros. And on the one hand, I get it. That makes sense. If you have a court order indicating no injury or no future care for the injury because it's resolved, you really didn't need an MSA. I think any one of us MSA vendors is happy to write you one. And Heather and I were in different spots back then. It's always helpful to write one, but I think people took a belt and suspenders approach. They wanted it written and then they wanted it submitted, even though that court order on its own did the trick. And I think CMS to say, I don't see a whole lot of value in reviewing that, I kind of get that. But the legal zero route is super important. And I think they wanted to try to find a way out of it and thought they could kind of quickly get out of it because they didn't have it in writing. Like, remember, what we just showed you a couple of slides ago was all we had up until really this year. We now get some more information. Legal zeros were kind of an extrajudicial process. So yes, the industry pushed back. MSPN did. I think at that point it was NAMSAP. I think Heather, you talked about it at the place where you were, at the place where I was. We were talking about it and pushing back. And thankfully, again, you had Steve Forey in place making a level-headed decision to kind of reverse course. And the agency has for a long time said, we want to give you at least 6 months heads up if there's going to be a change. And that's exactly what we're looking at coming up here when we get to kind of what the new reference guide says. But we're still in history here. And yeah, this was a bizarre thing that happened. Like you said, Heather, it was like basically overnight. And thankfully, everyone in the industry, we've got a lot of really talented folks here who pushed back and kind of quickly got the process reinstated. That being said, prior to that, you didn't even have to submit medical records for a while. When you wanted a legal zero approved, you submitted the pay history showing no medical paid, no indemnity paid. And it was a pay history from the date of injury forward, right? It was a full pay history. And that pretty much got you where you needed to be. You said, look, it's a denied claim. They haven't made anything. Or if you're in a jurisdiction that allowed a paid without prejudice period, you explained that away and you got these approved. They didn't even need to see the medical records. I'm going to turn it over to you, Brendon, and Heather, unless you have more to say on this, we'll get to, CMS chipping away and making it more and more difficult for us to get these things approved.
Yeah, so there weren't any real hiccups after that whole 2016 kerfuffle, we'll call it. So things were operating smoothly. CMS was routinely approving $0 allocations if they were submitted on a medical basis. So you had the court order or the treating physician statement. And for the longest time, they were approving legal zeros where the payment history was clear that the employer, the carrier, didn't pay anything on the claim. But then I would say probably either maybe early 23 or mid 2023, there were some inconsistencies in the legal zeros that were being submitted to CMS. Later on in that year, 2023, a CMS official, specifically, he was the head of the Medicare Secondary Payer MSAs division at the time. He said at an industry conference that there was, quote, a certain threshold settlement amount which would automatically trigger, quote, an internal review at CMS before the legal zero MSA on a fully denied claim could be approved. So effectively what he was saying is, hey, you could have this fully denied legitimate claim, submit that $0 MSA proposal to CMS. But if the settlement amount, if the anticipated settlement amount was high enough, then CMS would review it and potentially just deny it outright and force the carrier and the employer to fund something for future medicals. At the time, of course, he didn't state what that specific threshold settlement amount would be, and he also didn't confirm what that internal review would look like. But that was an interesting statement that was made because when you go through the process of actually submitting an MSA to CMS, you have to submit a cover sheet, and within that sheet, you have to tell CMS the anticipated amount that file is going to be settling for. And CMS uses or is supposed to use that metric to figure out whether this is an MSA file that actually meets CMS threshold, right? Because if it's under threshold, so say it's for a Medicare beneficiary, but you estimate the total settlement amount is going to be $5,000. If you were to submit an MSA to CMS, CMS wouldn't review it because it's just under threshold. But it's interesting that CMS was apparently using that threshold also to force carriers to fully fund MSA. So that happened in 2023. That was pretty strange, completely against CMS's, or not identified anywhere in CMS's written guidance. And then later on, that same individual from CMS went even further to an even greater extreme. And he said a year later, that quote, "It is the existence of a settlement, not who has primary payer responsibility, that drives a workers' compensation MSA. Liability is not a consideration." So his interpretation was that CMS doesn't care if the workers' compensation claim is accepted or denied. Doesn't matter at all. If you settle a claim and it involves either a Medicare beneficiary or an individual who meets reasonable expectation status, then something has to be set aside for future medicals, which is completely against all current, or at the time was against all current CMS policy guidance, which leads into a good foreshadowing of CMS just deciding to cancel the zero MSA program outright because they couldn't quite nail down the metrics that they wanted to employ.
Yeah, absolutely. So this kind of brings us up to present moment. I mean, there's a little bit of history that's kind of not woven throughout, and that is that CMS, particularly Steve Forey, had approached some members of MSPN, particularly the Policy and Legislative Committee, about doing away with review of zeros, both medical and legal. There was some movement to try to help do that pre-COVID. It really kind of died out. And then late last year, November, December-ish, or maybe it was like throughout the fall, Steve Forey brought this back up and said they did really want to get away from reviewing it. MSPN did push back because the membership had changed since several years before, and membership really said, hey, look, people are using your voluntary review process. You should probably just keep it the same. And CMS said, nope, absolutely not. So just in January 17th, they released a notice in their reference guide, and they gave a 6-month heads up that they will no longer accept or review WCMSA proposals with a $0 allocation. That's starting July 17th. They're not going to do that. Entities should consider some following information, though, and they went to outline information that we already saw before. So the 2 check marks here at the bottom of the list, these are the first bullets that Heather went over in that original language. they want to make sure that you're not getting too cute. You're not trying to maximize other parts of the settlement while minimizing the future medical, right? The facts of the case have to demonstrate that the injured individual is not being compensated for past medicals, that kind of stuff. So they kept those, they codified them, and then they broke out the four different criterion essentially that Heather and Brendon will go through here. And we'll talk through a little bit about kind of really where the legal zero now starts to show up. And they've actually broadened it more than I think the industry even requested pre-COVID. We had asked for the MSPN and the committee had asked for some broader language, particularly for those of us who are in states like Minnesota, where I don't have a pay without prejudice statute, but there is a statute that says, hey, just because I paid a payment or two for medical doesn't mean that the claim is compensable. So there's some language in here that I think we're really happy about, which I think Heather talked about earlier. So Heather, do you want to dive into the first two criteria here?
Yeah, for sure. So the two criteria in the new reference guide regarding zero MSAs, it says the individual's treating physician documents in medical records that to a reasonable degree of medical certainty, the individual will no longer require any treatments or medications related to the settling work comp injury or illness. And the second condition would be the workers' compensation insurer or self-insured employer denied responsibility for benefits under the state workers' compensation law, and the insurer or self-insured employer has made no payments for medical treatment or indemnity except for investigational purposes. Prior to settlement, medical and indemnity benefits are not actively being paid, and the settlement agreement does not allocate certain amounts for specific future or past medical or pharmacy services as a condition of settlement. All right, Brendon, the other two conditions?
And so, thanks, Heather. So in the next two, so CMS finally, thank goodness, for the first time in writing, finally acknowledged legal zeros and when legal zeros could actually be approved. So the third and fourth bullet points are, number one, a court or CMS will approve a $0 MSA, essentially when a court, commission, board, or board of competent jurisdiction has determined by ruling on the merits that the workers' compensation insurer or self-insured employer does not owe any medical or indemnity benefits. Medical and indemnity benefits are not actively being paid, and the settlement agreement does not allocate certain amounts for specific future medical services, right? So just your general denied claims, but CMS expanded that even more, and they also included workers' compensation claims that are denied by the insurer or self-insured employer within the state statutory time frame, allowed to pay without prejudice if allowed in that state during the investigational period. Benefits are not actively being paid, and the settlement agreement does not allocate certain amounts for specific future medical services. So this last bullet point is huge. It's great for, as Annie mentioned, not all states have these quote unquote pay and investigate statutes. So you take a state like California, for example, there's a statute which allows the employer and the carrier to pay for a certain period of time up to a certain amount, just purely to see if this is a claim that the carrier should be responsible for, a claim that should be compensable. So just by nature of paying benefits, the employer then is not being forced by some silly CMS policy to fund a full-blown MSA, when under state law they can make payments and they're not responsible. So this last bullet point, number 4, is a huge benefit to the industry.
Yeah, absolutely. Just, basically breaking it down, like it's interesting the way that they chose to kind of go through the 4 criteria, because 1 and 3 bullet points end up being the medical zeros, right? That was what we had before. And then 3 and or 2 and 4 end up being legal zeros, essentially. The one without the pay without prejudice, and then the other one with, investigate in a state like Minnesota, and you can still do this, which is great. We wanted them to recognize that, there's some leeway there. So breaking it down, what does this mean? If Medicare is no longer going to look at 0 MSAs, does that mean that these go away, that you can't do a 0 MSA anymore? Absolutely not. 0 MSAs still exist. There are still tools in your toolbox. You should absolutely still continue to use them when you meet any one of those criterion. It's really, you know, getting and obtaining a zero MSA from a qualified firm like Sanderson Firm is really going to help you sort of, you know, protect yourself, protect the claimant, protect all of the parties involved if CMS later tries to bring a claim or denies payment. So these will still continue to exist. You cannot submit them after July 17th. So CMS will continue to review them for a few more months. They're still going to be big sticklers about it. You basically, you know, have to dot all your I's, cross all your T's, and really make sure that particularly legal zeros are well supported. But I think this all begs the question then, okay, you can't participate in the review process anymore. Is there an option for you to get indemnification of these, right? So many people, when something is under threshold, go and get indemnified products, right? That's probably why you're on our webinars. You might utilize one of those products. We are super pleased and super excited to announce our zero indemnified MSA. We foreshadowed it a little bit last time. Heather's going to talk about it now here in our next slide, but we're super excited to be able to offer this product because we know that if you meet any one of these criterion, we feel comfortable backing that up. So Heather, turn it over to you.
That's right. Super excited that we now have a indemnified zero MSA offering. And we figured, why wait until July? We feel so strongly, like Annie mentioned, that, you know, as these cases meet these criteria set forth by CMS, why would we not back them, right? We certainly will take a look at the individual circumstances of each case and make sure that it warrants a zero. You know, it's interesting, just one before I get into a little bit about our indemnified zero MSA product. I've heard some different things since this announcement has come about, and I've heard there's some very conservative carriers out there. I'm not going to name them in particular, but they require their employers and who's ever on their program that they have to obtain CMS approval if review threshold is met. And I'm hearing that they're thinking about, with this change coming, that they're just on those circumstances where they would have had a zero, they want CMS approval so bad that they're actually going to fund an MSA, which is just crazy to me, because if the circumstances warrant a zero, and you can defend it and you have a firm that will stand behind it, why are you now going to fund an MSA when you don't need to? I've always felt that CMS, as I mentioned this earlier, and obviously you can tell we're all a little bit excited that CMS is not going to review zeros. Why have we been asking the federal government, CMS, all this time to agree with our doctor's medical opinion that no future care is needed? Why have we ever been giving CMS deference as to whether they agree with our state law reasoning or our court order, right? It's kind of crazy when you think about it. CMS should have probably never reviewed these in the first place. So hallelujah. Let's move forward with our zero MSAs and still able to settle our cases, even if they are above settlement review threshold. CMS review has always been voluntary, right? So it'll be interesting to see what these very conservative carriers do in the future, and if they do now fund MSAs just so they can get CMS approval. But for those of you that truly understand that there's minimal risk here, the zero MSA product is going to be really helpful for you. So basically our criteria are pretty simple. If you've got a medical zero, basically a situation where your injured worker's treatment has completed, and we have some kind of statement in writing that treatment has resolved, we're not going to be as staunch about that treatment opinion as CMS is. We believe that if we have a defensible opinion, either from the treating physician or a qualified IME or QME, AME, that, you know, clearly states with evidence and convinces us that no future care will be needed, then we would approve a medical zero there. Also, for the legal zero aspect, we're also going to provide our indemnified zero iMSA when there's been limited or no payments made for medical and indemnity. And certainly if you have a final ruling on the merits indicating no future care, that's helpful as well. But as I mentioned earlier, we realize that that's not always the easiest to obtain. So we're really excited to have this product live now. We just basically did a soft launch of this product a few weeks ago. We already have several in progress here at Sanderson Firm, both medical and legal zero. So we're ready to go. If you've got cases that meet these criteria, feel free to send them on over. But, you know, essentially the advantages are that you're going to obviously have savings, right? I was talking earlier about some of those conservative carriers that are now going to fund an MSA to get CMS approval. I think that doesn't make sense to me, but I can't change their minds for them. But certainly having an indemnified zero, protects the parties. Challenge from Medicare. I don't believe that Medicare is ever going to challenge these, but we'll see. We're going to talk about the interplay just briefly between the new MSA reporting that's coming about next month and how Medicare might look at zero being populated. But essentially we're gonna still protect Medicare's interests. We could do these in Medicare beneficiaries settlements or reasonable expectation settlements. And again, we're gonna have an ironclad case. It should Medicare ever come knocking on our door and ask why we did a zero, because we're going to take the relevant case facts in state law and what Medicare has dictated in their latest reference guide and make sure that we have a defensible zero iMSA.
Okay, so the big topic this year is MSA reporting. So the title of this slide is Zero MSA Reporting, but I just want everyone to keep in mind that this actually applies to all workers' compensation MSAs. So effective April 4th of next month, we're few weeks away, way less than a month. All workers' compensation claims involving Medicare beneficiaries with settlement amounts over $750 must have Medicare set-aside information reported to CMS through the Section 111 Total Payment Obligation to the Claimant TPOC reporting field. And this is the case even if an MSA was never prepared or a Medicare set-aside was prepared, but that amount was zero. So this is just full stop. You've got a claim involving a Medicare beneficiary, whether you prepared an MSA or not, Medicare set-aside information needs to be reported to the government. CMS is adding 7 new fields to the TPOC field, specifically addressing the workers' compensation component. So 7 new fields will be 1, the workers' compensation amount, obviously, the workers' compensation MSA period. This is the amount of time that the workers' compensation fund is supposed to last. Whether the MSA, if there is one, if it's being funded via lump sum or annuity. If it's being funded via annuity, CMS wants insurance carriers and self-insured entities to report the initial deposit amount and the annual anniversary amounts thereafter. If this was a Medicare set-aside that was submitted to CMS, CMS has requested the case control number. So if you submit an allocation to CMS, CMS automatically generates this case control number. So if this was an allocation that was submitted, you would simply fill in the assigned case control number for that MSA. And then lastly, CMS wants to know if it's being professionally administered, who that professional administrator actually is. So that's the major change happening in a few weeks. And as you'll see in later slides, this information is required. And if it's not reporting, it could result in some very costly civil money penalties. So getting into the specifics on MSA reporting, but just specifically applying this to $0 MSA, since we're talking about zeros. And I know last webinar, we had a question from an audience member of, okay, this claim is settling, but there's a $0 MSA. Like, how do I functionally report nothing to the federal government through TPOC reporting? Do I report zeros? Do I enter hyphens? Do I enter a bunch of nines? How do I do it? So here is the mechanics of how you report a $0 MSA to CMS. So in the work comp MSA amount field, you would populate a 0, and that would suffice. In the workers' compensation MSA period field, you would also populate a 0. And the lump sum or annuity indicator field, you wouldn't enter a 0, you would enter a space. And you can only enter, and entering a space is the only valid key entry, because this field is an alphabetical field only. So if you were to populate every other field correctly and enter a 0 into this field, it would actually cause your entire, not just your MSA reporting record, but your entire TPOC record to fail. And it would be as if you never reported the settlement at all to CMS in the first place, which if that's not reported or not corrected within a year, your organization faces civil money penalty exposure. So initial deposit amount, if it's a $0 MSA, this amount would be 0. Your anniversary deposit amount would be 0. Your case control number, this is similar to the field above. You can't enter 0, that would be invalid. You have to enter spaces. And this one is a little confusing. I would imagine this case control number will actually trip some people up because the field is titled case control number. So you would think that you could report numbers or zeros in this field. You can't do that because technically when CMS issues the case control number, it leads with actual letters. So it'll say like WC for work comp and then a bunch of numbers. So you have to enter spaces in this field. If you don't, if you enter numbers when nothing was submitted and it's zero, it's going to result in as if the record was never reported to CMS. And then lastly, in the professional administrator field, if the MSA is zero, then a digit of zero is appropriate to report to CMS. So keep this handy to the extent that you handle the Section 111 reporting for your organization, because if it's a zero and you get one of these wrong, it could be catastrophic.
Yeah, thanks, Brendan. We have a couple questions in the chat that kind of pertain to this. So you cannot use an NA instead of a space. Brendan is very, like, this is what he's talking about is very technical. So please, reference the slide. We'll make sure to send it out. You do not need a Medicare release form signed in order to prepare a legal zero MSA or an indemnified MSA through us, because it will not be submitted. I believe that's the question there. In terms of what we need to prepare them, we definitely need for legal zeros. The main factor is going to be your pay history, and in pay history for the entire claim to see that there's been no medical or no indemnity paid or limited amounts of that paid, et cetera. In terms of a medical zero, we would need to see the relevant medical records that indicate no future care. So that may be within the 2 years of medicals. But yeah, so hopefully we've cleared up those questions for you. Yeah, we're heading into the home stretch here. So what I will talk about next is just the interplay with recovery. Not a whole lot of time on this. The main thing is, just because you have $0 set aside for future care doesn't mean you don't have to clean up the past care. Obviously, if it was an admitted injury and the person's injury resolved, that's great. But the conditional payments relate to the admitted injury and they need to be cleaned up. You can't cost shift that onto the taxpayers. With the legal zero, Medicare really takes the stance that, yes, you denied it, you didn't pay anything, but if you didn't want to have to pay conditional payments, you should have tried the case, and if you won, you wouldn't be responsible for them. So the parties do still need to clean up the conditional payments. Typically, on a denied claim, that's going to be at the BCRC, and it's going to be in the beneficiary's name, and it will have to be dealt with by that side, or using a consent to release form or a beneficiary proof of representation form with a vendor like us. So that's it. You still have to clean those up. Same with Part C and D. You have to check with the Medicare Advantage plans and the prescription drug plans. Use your paid act data to leverage that. So then we'll quick talk about, I think, settlement language. Or yeah, and I guess I had this as well. You can always ask the individual this information and work with us. But yeah, we can move on to the next slide then.
And just real quick, since we're running out of time here, just to comment. Yeah, so if you have a settlement involving a Medicare beneficiary or someone who meets reasonable expectation status, so they've maybe, for example, applied for Social Security disability insurance, maybe they have end-stage renal disease, etc. You should reference in the settlement language, if you have an MSA, how you reach that MSA amount and why it's appropriate. Or if you don't have an MSA, since we're talking about zeros, talk about why a zero MSA is actually supported. And to do that, it would be appropriate to at least reference somewhere in there the new section 4.2 language from the WCMSA reference guide, highlighting the 4 specific scenarios where CMS agrees that a $0 MSA is appropriate. So you definitely want to have that handy, and it's appropriate to put this language in the release just so that all parties can reflect and just think about and say and just confirm, yes, this is scenario 3 out of the reference guide language, so a zero MSA is appropriate. Because if it doesn't fall into any of those 4 categories, and obviously the risk is, CMS would deem this $0 MSA or no MSA to be a burden shift, and it could result in a denial of benefits to the Medicare beneficiary.
All right, so one of the questions we get, and it's a very unsatisfying answer, we just don't know. Will CMS audit settlements? There's no directive civil money penalties, but failure to populate them in the new field could lead to that hard error. Brendan talked about that. CMS has said to some stakeholder groups that they reserve the right to inquire about settlements where they see a huge gap between the total settlement amount, the TPOC, that total payment obligation to the claimant, and the amount allocated for future care. So if there's, and this kind of gets at what Brendon was talking about earlier, right? CMS used to say, oh, well, there's some threshold. We're not going to tell you what it is, where we think there might be enough money there for future care. So if you have a settlement that's maybe $275,000 and you have a 0 MSA, because it's denied, they may want to look into it. So definitely, like Brendon said, document the rationale for the 0 in your file, in the settlement documents. And we don't know what the likelihood that CMS will audit these on. They should promulgate rules around this. They should have a process, but we don't know. So more to come on that as this sort of rolls out starting in April and beyond.
Okay, great. So just want to let you all know of our next webinar. It's going to be held on April 17th, again at 1:30 Eastern Time. Please do notify us if you would like to be automatically enrolled in our future webinars. Email us at spotlight@sandersonComp.com. As I mentioned earlier, I just want to mention again, we're a full suite MSP services provider and law firm, offering everything from MSAs to Medicare conditional payment services, Section 111 reporting services, and as a law firm, we can also provide legal advice and MSP best practices to organizations. Just want to also tell you all briefly about a new product also that we're about to roll out. It's called the little a MSA, which is our abbreviated Medicare Set-Asides. So as MSA reporting is now coming through in April, right? And you have settlements that warrant future medical care for Medicare beneficiaries, but it falls under CMS's review threshold. Let's say you settle a case for $15,000 or $20,000 with a Medicare beneficiary, and they require a little bit of medical care. We're going to offer an abbreviated MSA. It's a more short form MSA. It's certainly more cost effective on the price point that we're offering for this, and we will also indemnify this AMSA as well. We're just going to look at 1 year of the medical history and payment history, and the total settlement amount obviously needs to be under $25,000 cohesively. If it's a Medicare beneficiary. If you have any questions, you want to learn more about our AMSA, please do contact us. We're excited about that. And just briefly, I want to tell you all, if you love MSP education, you'll love MSP College. These are 2 educational programs that Sanderson Firm has put out to the industry. We have the MSPA, which is the Medicare Secondary Payer Accreditation, which covers all things MSP. This is a fully virtual and online course taken on demand at your own time frame. Go through the 9 modules and learn all about MSP, take a final exam, and you are now MSPA certified. So we are proud of that program. We also have a very specific certification around Medicare Set-Asides, the Medicare Set-Aside Certified Planner. This is a great course. It's 11 modules and consists of a final exam. You do not have to write an MSA at the end, but it will walk you through actually allocating an MSA. So it's great for those that really want to understand MSAs better. If you're an organization that receives MSAs from others, or you want to actually learn how to write an MSA and submit to Medicare, this is also fully virtual and on demand. So definitely check out those programs. And if you have any questions on them, please let us know. We're right at the top of the hour, and I want to thank everybody for joining our webinar today and thank my wonderful co-panelists, Annie and Brendon. Thank you. For those of you that might want to reach out to us post-webinar, please do. Our email addresses are on the screen.
For anyone who wants to get registered for these in the future, I think you were just looking for that email address. Again, you can email any one of us. But the email to get signed up for that is spotlight@sandersoncomp.com. Spotlight, all one word, @sandersoncomp.com. A few questions around that. So thank you everyone so much for attending today.
Thank you. Have a great day, everyone.
Thanks, everyone.